Law Reform Commission, said Attorney General must follow up the recommendations made by this court with other organs of state, namely Parliament and the Executive. And 2, the court also said that the Attorney General shall report to the court within 2 years from the date of this judgment the measures that have been taken to implement these recommendations. 3, the court may thereafter make further orders and recommendations as it sees fit. This was on 26th of August 2016. So the Attorney General was mandated ordered by court to report on the progress of implementing these recommendations. It's not the Law Reform Commission which was asked to do that. But of course, if a matter is referred to the Commission, we would willingly do it. And we don't have to, in ordinary cases, the Commission takes initiative to carry out reform. We have that mandate. But in some cases where...
Is this an extraordinary case?
Well, the matter is that it has been referred specifically to the Attorney General. So, and the Attorney General has not referred this matter to the Commission. So that's why we have not implemented these recommendations. But we specifically picked out this one because it was relevant to one of the articles that was amended in this draft bill.
Chairperson, are there any other recommendations to your knowledge which are relevant? No, you see, there may be, really, that's what I've been saying. If you may listen briefly, when I ask a question, I'm speaking from a point of ignorance, so I need knowledge. And when I get an expert like you, charged a rigorous responsibility to give me that knowledge, you do. So are there any other recommendation to your knowledge or to the knowledge of the Commission and in that judgment which are relevant to the electoral process in this country? And if so, that is the question I asked Mr. Chairman at the beginning. What are they?
And of course, the second one, what are you doing about them? She's answering why she has not done, why they have not done anything. Madam, that is very clear. Yeah, very clear.
I wanted to add that the Supreme Court actually mentioned 2 years, within 2 years. In other words, these amendments or reform were supposed to be done within the next 2 years. And by now, it's almost 1.5 years. So we are remaining with maybe half a year. That is why...
That by 2 years, maybe around May?
Yes.
August? Depending from when you start counting. Okay, let's get, this is very, very crucial part of the question from Bugweri. And if you need time to identify them, if you have them off the cuff, we would really love to hear them. If you don't have, it's not something you can gloss over it.
Yeah.
And Chairperson, the Law Reform Commission on its own has a mandate to dig into and look into laws that affect the management of society on your own, even without the Attorney General, without Parliament, without any other MDA, and bring them up for amendment or for reform.
Honorable Chair, one of the recommendations that is relevant
to the microphone.
Yeah, is the one concerning the time for filing and determination of the petition. The other one is the time for holding fresh elections. So that is...
You have to be specific. The time for holding fresh elections, the Kenyan way, or...
Okay, I'll read it. If I may read the recommendation.
No, sure. You have the liberty.
Article 104 Clause 7 provides that where a presidential election is annulled, a fresh election must be held within 20 days. And well, we actually addressed it in our presentation. I don't think I need to address it. I don't think I need to address it. The other, in my view, the other recommendations do not require registration. For instance, if you look at the recommendation 7, talks about donations during the election period.
It's about what?
Donations.
Okay.
During the election period.
Would you, honorable colleagues?
Doesn't that have an effect on the presidential powers as chief executive? And you think there is no requirement for, it has no constitutional ramifications?
Not on the, I think it is on the, what is this act? The Presidential Elections Act, not on the Constitution.
Yeah, but no, we are talking about, the court was addressing the issue of an incumbent who continues to make donations.
Brown envelopes.
Those brown envelopes.
Yes.
And behind the curtain of being the sitting president. I think you need to contextualize that. You know, you need to read the judgment as a whole. They were referring to a complaint that related and emanated from the exercise of incumbency, the powers of incumbency. And that's where I'm asking, and you think that has no constitutional connotations whatsoever? For example, is there a statute that governs those donations, such that if we are to amend, we amend statutes?
Honorable Chair, as I said in the beginning, we addressed only the issues in this amendment bill, constitutional amendment bill. But if the Commission is required to do further study, we'll be happy to do so. But we focused on the proposed bill.
Okay, honorable colleagues, why can't we take a decision on that? They seem to have focused on the 4 clauses, and it is apparent that the technical arm for the law reform and what is we are involved in through a private members bill is that we need this, especially that when the Supreme Court is referred to, the decision in that case, can we take a decision that we request them to bring? Yes, Honorable Katundu, that was your question. What do you think?
Yeah, thank you very much, Mr. Chairman. And I'm not faulting them in any way. But I like to request them to recognize their mandate, first of all. And as lawyers say, and I'm sure there are many lawyers on the Commission, matters related thereto. So, in considering these 4 clauses being proposed to be amended, the Commission should have considered the matters related to. That's number 1. Number 2, even when you look at the justification of the bill, it talks about objects, actually the objects of the bill, it talks about this very case, the election petition number 1 of 2016, the right honorable Mama Mbabazi against His Excellency President Museveni. That's one of the objects of the bill. What were the recommendations? So I thought they should have studied the objects of the bill, looked at this case, all the recommendation, addressed their mind to why we're only picking out 1 or 2 and leaving out the rest.
Can I give you some information?
I'll take it, Mr.
Through you, Chair.
Since he's your classmate.
Well, committed. Thank you. Mr. Chairman, when you look at the introduction and background part of the presentation, that one spells out their mandate. And this is what their mandate is: to study and keep under constant review the acts and other laws comprising the laws of Uganda, with a view to making recommendations for their systematic improvement, development, modernization, and reform. And they have addressed their minds to the judgment of the Supreme Court in Amama Mbabazi versus Yoweri Kaguta Museveni. And the recommendations in this particular in this particular judgment are diverse. They opted only to address their minds to the four corners of the bill. Yet their work actually is to keep the laws under constant review and development, and actually to make recommendations. So I wanted to give this information, and I know at the end of the day, the Honorable Katuntu will ask them whether they have ever made any recommendation.
I like the way you share your brain. Yeah, I like the way you think.
You know, I am his member of Parliament.
Okay. Horace, you've been given a question to ask.
Which is very unusual. So anyway, Mr. Chairman, you know, yes, we are looking at the Constitution Amendment Bill, but when we look at this institution that comes to this committee every year to look for money, such that they perform their mandate, and we find a little bit of shortage on their part, I think it is our duty to let them know. You know, when you look at this subject, commissioners, it's caused a lot of controversy in the country, and we would be expecting people like you to say, well, the controversies arose out, some of them arose out of the recommendation of the Supreme Court, that of Amama Mbabas and even that of Kizza Besigye. So by now you should have, as the Honorable Segona says, come up with recommendations. Why you cast your net wide, and then we will not be looking at one particular clause and the whole country is running around and so on because of a particular clause. Yet we know the bigger problem, and you are Ugandans actually. You are not like mechanics. You are Ugandans. This electoral system should be able to be as hygienic as possible because you are beneficiaries of it. So as I end, Mr. Chairman, I think we need to remind them of their responsibility, and they know it, but in regard to electoral reforms. And they now know that actually you have less than, is it 6 months? 4 months. So are you going to do this thing in 4 months, madam? Oh, since there is a court judgment, it has absolved you of your statutory responsibilities. Do you want me to interpret it that way? That now this is no longer our mandate because there was a court judgment asking the Attorney General to. I thought that would be the wrong interpretation.
I think the court judgment actually has helped you to point out what you need to do.
Exactly.
And it's a judgment. You don't have to wait for the Attorney General. And I will join Honorable Katuntu to really tell you that as much as we appreciate what you're doing, I think we were expecting more than what we are getting. But we can understand the challenge that you restricted your presentation to what was before us. So do you want to answer the rest as I get to another set? We have already electoral commission here. Have you exhausted?
Honorable Chair,
you make some undertakings here.
Can I say something?
Sure.
When we came here, we were invited to make a presentation on the bill. We are not anticipating other things. But I also want to mention to the member, to the committee, that, and I mentioned it in my presentation, that the Commission carried out a study on electoral laws in 2013-2014, and actually made recommendations, and we will send the study report with recommendations to the Ministry of Justice. So we have done some work, and I think most of those issues will probably be answered in the study report. But we had not anticipated that would be asked questions that are outside, because the letter was very clear. Was very clear about what we should talk about.
Can I help you on that? What is in that bill is the case. The right honorable Mbabas versus the Attorney General, the President Museveni and the Electoral Commission. That was quoted in the bill. So our anticipation that you would say, actually, these are not the only ones. there are other recommendations that the Supreme Court made, and they are urgent, we would have given you 99.99%. But your attempt to say you restricted yourself to the bill actually is not helping you, because the bill was referring also to the Supreme Court decision. So on that note, I thought, I know you very well, you would make some undertaking, but I don't want to cheat for you exams.
Mr. Chairman, just to remind the Commission that apart from appearing here over this bill, they have a running, not mandate, not even use, because maybe the word that is confusing them is mandate, duty. And the duty is both statutory and constitutional. And among others, to advise and make recommendations. I had expected her to say, I advised the Attorney General. Among the people to advise is Parliament. If Attorney General is not responding, they have not advised us. Let them also not forget that this committee supervises them.
That reminder, I think, is made in good faith, not to intimidate you, but yeah, do you want to, other colleagues, what do you think? Should take another round?
As a way forward, let me suggest.
Or you just answered one? Yeah, let your colleagues.
Honorable Chair, I request my colleagues to answer some of those other questions.
And your colleague, you are referring to the PS, or was I see him clearing his voice?
Honorable Chair,
I can cross over.
for the benefit of honourable members who came when I introduced myself, I'm called Lucas Omara Abong. I'm Secretary to the Commission. I'd like to speak to some of the questions that were raised.
You may speak through the microphone.
I'm trying to bring it closer.
Yes, sure.
Thank you. Honourable Otto, I believe, asked about how we prioritize dealing with laws or dealing with the constitutional provisions. How we prioritize what we do. What happens is that we prioritize laws in three ways. One, government through the ministries, departments, agencies may bring a matter to us and request that we handle them. And when we receive that, we program and handle. Two, we also scan the environment and make suggestions, propose, discuss internally, and prioritize areas that we handle. Secondly, within the framework of the justice, law and order sector, the sector prioritizes certain areas of reform that we must handle. For example, in the fourth sector investment plan, the justice, law and order sector is prioritizing land justice and commercial justice. So we take those as priorities. But yes, Parliament is one such agency that can give us priorities, and we prioritize. To try to correlate all these varying interests, in the course of this year, we are starting a process of developing a medium-term reform plan, reform program, where we are making consultations with as varied a spectrum of stakeholders as possible, so that within the next 3-4 years, we know roughly what areas to be focused. So we hope that in the process we'll be engaging with the committee and Parliament so that we take these priorities. The other question that Honourable Otto asked was related to the interpretation of the Constitution. I think I want to agree with him that there are various approaches to interpreting the Constitution, but ultimately it's the authority that is assigned the responsibility to interpret which will adopt what approach to develop, and that is the Constitutional Court. And that ties up with what Honorable Kajara said about age not being a factor for discrimination. I want to believe that Article 32, read together with Article 21, would give us an indication. Article 21 specifically talks about areas where you would look for when they're looking for discrimination.
Yes.
And age is not one of them. But when you're looking at affirmative action,
which is different,
they're saying don't restrict yourself to areas where the Constitution has delineated as discrimination, but there may be other areas of vulnerabilities, and one of them is age. So in making that distinction, I think one knows that it's not specifically that age is a matter of the Constitution. The Constitution considers that microphone switched off as discrimination. There was a question about mischief. I think Honorable Kachuntu alluded to the fact that we did not mention what that mischief was, and I think Honorable Ottawa also made reference to the mischief. I think we made the assumption that the mischief was a given. We made a wrong assumption that the mischief was given. But specifically, we didn't want to, so to speak, add into the controversy, as it were. But our view was that as this committee and Parliament undertakes consultation, they would be better placed to determine whether there is merit in that mischief or not.
I didn't want to interject, but please allow me to, Mr. Chairman. Thank you, Mr. Chairman. I didn't want to interject in Mr. Omala's presentation.
And I believe you still want...
But now, please, Mr. Chairman, allow me, because my question shall touch exactly what he's saying. Like you said, the sponsors of this bill had a justification of discrimination. And the issue herein that we are presenting is the difference between limitation and discrimination. Therefore, when you read Article 32, and I read it before you, it says, notwithstanding anything in this Constitution, the state shall take affirmative action in favor of groups, and I repeat, in favor of groups marginalized on the basis of gender, age, disability, or any other reason created by history, tradition, or custom for the purpose of redressing imbalances which exist against them. Now, when you look at the clusters of groups, they may be, let's say, youthful, women, the elderly. Now, in this case, and the disabled, to mention but a few. In this case, in your opinion, do you think the elderly are discriminated against? And in any case, what is the threshold cap of the beginning of the age of the elderly to its maximum in Uganda? If we are to agree here that the group we are talking about in moving this amendment is that of the elderly, and the threshold to their access in participation in politics starts from 60 years. Do you think there is a particular group that we've undermined and we've discriminated against if we blocked this bill or if we promoted it? Is there anything we shall be curing? The same happens if we lower the age limit for presidential or local council 5, and we want your honest opinion on this, from 30, that is for the chairpersons, and from 35 of the presidency to, let's say, 18. Is there any group that we would have left out in that case by giving justifications of the following? For example, in your opinion, do you think a person at the age of 18 years would have not only the necessary qualifications of A-level in Uganda to run as president, or as LC5? And 2, in case of presidential, would they have the necessary financial capacity and access to acquire 2/3 signatures from the entire country? Therefore, in that case, what would we be curing? And in any case, if we lowered it to 18, why not 3 years, or 2 years, or 5 years? So that is the honest opinion we need from you, rather than giving us vague answers of saying it will be your Parliament after consultations. Now you, as the person that is mandated...
Actually, we are consulting them.
Now we are consulting with you at the moment. Now you that are experts and that have traversed various nations, and knowing that the mover and the movers and sponsors of this bill hinge their justification on discrimination, and aware with the examples you've given us from all over the world that at least there is a threshold that each country follows. Is there discrimination or limitation? You can couple it up with this, that for someone to run as president, they ought to have requirements of a member of parliament, and you clearly put it in your presentation. The qualification of a member of parliament, or someone shall not be qualified to run as a member of parliament, according to Article, I think, 82C, in case they are active traditional leaders. Do you find that discriminatory or limitational in its way? Why is it that when you say power belongs to the people in Article 1, is a traditional leader not a person within the laws of Uganda? And finally, the president, let's say via Article, I think 95 or 90, is given a lot of powers that for as long as they are holding the office of presidency, they cannot be, no criminal or civil proceedings can be brought against them. But Article 21 clearly says that all people shall be equal before the law. Is the president and all other Ugandans equal? Are they equal before the law? Was that limitation or discrimination? So try to give us your view, your honest view. We are consulting with you as to whether there is still justification to remove that, or when we continue removing what we term as discriminatory and not limitation, we shall tamper with the entire document called the Constitution. Thank you.
Mr. Chairman, in a second,
if I may qualify my question.
In a second, they referred to some literature which they read at page 3. And of course, it is that literature that makes them think that this was a matter of course, therefore not controversial. Can we also share part of that literature which they reviewed? Thank you.
Honorable Chair, if I may qualify my question. Honorable Chair, I will go a little bit deeper if it may help. In section 15 of the Canadian Charter of Rights and Freedom, which is part of the 1982 Constitution of Canada, when being interpreted on the ground of discrimination, it did not include same-sex case in the Alpine case versus Attorney General of Canada, which was dealt with by the Supreme Court of Canada, common law jurisdiction. Section 15 does not specifically talk of same-sex case. In interpreting it, the Supreme Court of Canada said that same-sex is an analogous ground of discrimination, although it's not specifically mentioned in the Constitution.
Mr. Chairman,
I would like to know.
Mr. Chairman,
I would like to know.
Mr. Chairman,
Yes. You are not comfortable with the same sex?
I am not, and actually it's one of those examples I don't want us to discuss.
I know how passionate you are.
Yeah, because we've had this debate in this institution before. We know our laws here that and some Honorable McMont, I'm touched because I am the one who moved the motion during the constitutional amendment process to bar same-sex marriages in the Constitution. It is unconstitutional. Just address yourself. It's prohibited. So, my colleague to start referring to a situation in any jurisdiction which says, or which sort of event, which even brings that unconstitutionality in issue. We have debated, it is clear, it is unconstitutional. So I would really request my colleague to give any other example
Honorable Chair,
other than that.
With your indulgence, now that you are invited to adjudge on off the veranda interventions, would it be proper that we all make our interventions, because they seem to be overlapping, that the team can respond at once? Because we
Honorable Chair, if I may finish.
Yes, just hold on. Let me give. Just hold on. You are now 3 left on that list. Honorable Nsereko has already made the intervention, but I note that. So, Honorable Solicitor from Canada, do you want to employ other examples? I know he has been practicing there. He's just about, probably what he wanted to give was as an example of constitutional interpretation. But, when you bring it here, others would say, of course, this is a record of Parliament. So you try to make it simpler and in a short form. That sex is not repeated here.
Honorable Chair, let me be on record that I've never been in support of same-sex, whether in Canada or here. Let it be clear. I'm simply talking.
I know that. I know your wife.
Yes. I'm a married man, and the ring is very clear. But principles of constitutional interpretation and support for whatever is a different matter altogether. I was simply bringing what is done in other what is done in other common law jurisdiction where we belong. Honorable Chair, I thought I should make that clear, but my question specifically, which I wanted to qualify, is whether when our constitution does not specifically mention age, whether even if affirmative action under Article 32 does not, talk about it, whether you could bring it as an analogous ground. Thank you. I just wanted to qualify it. Thank you.
I know you are attempting to respond to all. Honorable Mpuga, was yours related to Canadian example?
Not to my knowledge, sir.
I've underlined my constitution for Mr. Makamoto.
I was on the list, Mr. Chairman.
Yes.
Thank you, Chair.
Yes.
Chair, I would thank the team for their presentation. I must confess, I enjoyed the lesson in jurisprudence and I have no regrets. I am only concerned, just like the colleagues have expressed their concerns, that when I heard you say that you understood their challenge, I thought I would understand it too, but I have tried to understand the challenge at their disposal. I have painfully failed.
I'm sitting next to them,
I have failed to understand.
I could see the facial expression, which you didn't.
I'm going to observe you, then through you I will appreciate the challenge. Chair, I'll take an example of page 5 in the Commission's reference to a certain mischief, probably referring to a mischief envisioned at the making of the Constitution. Apparently, Mr. Omar made a reference to the fact that I never wanted to make an allusion that would be seemingly controversial And I would like to imagine that professionally, when you are advising, it's never controversial because we are consulting. I would like to imagine this as a village consultation meeting down in Kajara. And
we are telling him to be as brief,
yes.
But yes, maybe that applies to all of us.
Yeah. Sure. And I just imagine if this were a consultation exercise, I'm looking for a takeaway. I'm here to consult you and make my conclusions and invite the country to partake of them. So you're telling me to go and look for the answers elsewhere. I'm constrained. So I would like to invite the Commission to consider this a double mandate. One, as a body mandated constitutionally, but secondly, also as citizens. Because if we are left in this kind of position, I do not know what's going to come out of Masaka municipality if I go to consult in Nyindo over the weekend. If professionals with a wider mandate are not able to conclusively and unequivocally make an intervention as to the best way of dealing with this, I'll make an intervention in the whole of Masaka submission. We are discussing discrimination. I would like to be advised on the extent of appreciating discrimination and marginalization, on top of explaining the extent of the limitations. You know, I find it is very compelling to appreciate before I would draw any conclusions relating to where we are. I believe the recommendations that are being referred to in the Amama versus President 7 case, one that just being mentioned as anecdotes, and we are not able to appreciate whether they believe that at the end of the day, this bill actually brings out the extent of the recommendations. For instance, some of the recommendations have been siphoned out but not implemented as they were supposed to be. Take an example of the latest changes at the Electoral Commission. There are very serious recommendations from this Supreme Court case relating to the Electoral Commission. And you've just had a recent change not addressing the same. So we are moving, addressing some of the issues raised by court as recommendations and jumping off others. And now we are stuck. Can we use this case as a basis, for example, to get over this challenge, and what are their key navigable paths to get out of this dilemma? I hesitate to accept, try this, try that. I want very concrete submissions from a body with competence, with capacity, and of course independence at that. Thank you.
Thank you, and that confirms you are the most competent body we are consulting now. Don't send us anywhere else. Yes, Honorable, not Veronica. No. Honorable Amoding. Yes, you're number 3 on my list.
Chair, I'm glad that you took note of the names. I was sitting quietly today because I thought that you'd rule me out of order. Mr. Chairman, I just wanted to make an observation because my colleagues have already made very fundamental points that I know the committee has taken note. But of course, for me, listening in, the first observation I make is that the Commission is running away from its duty. And for me, sometimes I can be as blunt as, sometimes very, very, very blunt, and sometimes offensive. Mr. Chairman, the controversy of this bill is around the issue of age and the discrimination there too, which some of the proponents of the bill allege is affecting some sections of the public. And so I expected that the Commission would come very clean and clearly on the matter of age. But they just mention it in passing. And I think they make observation of the article which makes this clear, Article 21.3. They just make it in passing, and yet I expected that they would come with a clear position as the body which is mandated with reform, review, and improvement of the law, knowing that this is really the issue at stake And well, I'm just reflecting and wondering why you've chosen to keep quiet, and I have the answer within me. And perhaps it's, well, you've chosen to avoid the political question, because you come back to Parliament and you again recommend to us that we may choose to make or choose to choose our position which we may be comfortable with, and yet as a commission you should have recommended the best way forward. And I remember when we were battling on this matter, some sections of Parliament saying let's have a constitutional review commission, others saying no, Parliament is sufficiently capable of handling this. Maybe you would have come out at that point to say, hey, look here, this is our role, this is our duty of reform and also sometimes initiation of law. And still you were comfortable, quietly watching the events as they follow. Again, when you are invited to the committee, you've just chosen to keep quiet about a matter which we expect you to make a clear response to. In your recommendations, I clearly see that you're leading us to the option of maintaining the lower limit and lifting the upper limit, because you're saying that we may choose to harmonize it in the East African region, which I know the East African countries, most of them have only the lower limit and not the upper limit. So I would take it that this is your recommendation as a commission. However, you have also observed that wide consultations need to be done. And you're quoting Article 1 and 2 and that of the Constitution, the power of the people, the power of the people. Do you really honestly believe that this is still going to support this process? Are you aware that some constituencies can't consult, cannot apply this power of the people in this particular instance? And so, Mr. Chair, I don't know if the Commission is alive to the political question that is before the country right now, or you've just chosen to, be in abeyance and be silent, and yet this is your mandate.
Honorable Chair.
Finally, Mr. Chair, for me, if I was sitting in that committee, I would even perhaps go ahead and make a recommendation which is way beyond this particular assignment and say...
You are the only one sitting in the committee. Which committee else?
No. If I was in the commission, the Law Reform Commission...
Okay, you're referring for this.
For example, I would have actually recommended and said, can we review the Constitution wholesome and even review the roles or the duties of the President in terms of appointment? The appointing authority perhaps is overriding all the institutions to the extent that even a body that is supposed to be independently giving us recommendations cannot come up with sufficient recommendations. I would recommend that even the appointing authorities' powers are trimmed in this instance. But I want to congratulate my sister, Honorable Monica Emiru, who I have not seen in this commission before. I think she's now a commissioner. Thank you very much, Chair. I was not here, sorry. I didn't, but I saw you, I just thought
Regine Hine,
you are one of the commissioners.
Are you attracted to the name, or?
She's my senior sister in women's work.
Okay.
Yes, Honorable Chair. I wanted to give this committee some information that recently the Constitutional Court made some pronouncement on how to deal with the political question doctrine in the famous case of Professor Twino Mugisha and 3 others against the Attorney General. It is a recent decision of last year that political questions should and must be handled by either the executive or Parliament. So let us do not seem to be pushing our technical team against the wall to answer political questions. That's the information I wanted to give the legal brains in this committee.
Can I have Honorable Veronica?
Mr. Chairman, before I really request your indulgence. You see, this is my comfort zone. No, I was seeking the indulgence of the chair, but if he does it, I keep off the mic. I
thought you were even about to conclude.
Oh, thank you, Mr. Chairman. Mr. Chairman, the issues of law interpretation and judgment interpretation is my comfort zone, like many of colleagues here. And I don't want something to go on record which misrepresents the facts. For example, when they talk of the executive arm of government, what is it? Because you see, executive arm of government is not about ministers or cabinet. It actually includes all agencies, including those who are before us now. They are part of the executive. So the mistake my colleague would make is to imagine that executive means the politicians. No, of course not. To mean that the legislature, it is this institution together with our support staff. So there is nothing wrong, in my view, Chair, with us asking this pertinent question to these, actually we call them technical people. They are our chief advisors. They are here to advise us because
next episode of Coke Studio Africa. Nishinsky from Kenya and Mafiki Zolo from SA create an incredible throwback track. Nasty C from SA and Nigeria's Runtown feature in this week's Big Break. And Yemi Alade from Nigeria and French rapper Youssoupha create an original smash hit. Only on Coke Studio Africa. This is where music meets.
Lost my first child, Felix, because I didn't support him and his mother during pregnancy and after birth. I learned the hard way and decided to go all the way for my second child, Naigaga. Unlike Felix, when Naigaga's mother was pregnant with her, I made sure she ate as advised. We attended antenatal care. And breastfed her from the first hour of birth. Felix suffered a lot from our ignorance. We never kept him warm and clean, breastfed him for a very short time, did not give him nutritious foods, and we were always in hospital, not for checkups, but admission. However, we did things differently with Naigaga. We returned her to the health centers advised for immunization and regular checkups. We made sure Naigaga slept under treated mosquito net and learned to wash hands at an early age. Naigaga is happy, healthy, and clever because we did things differently. I learned the hard way and decided to go all the way with Naigaga.
That's his way of taking. Here is your order.
I think this is not exactly what we ordered. I ordered a Coca-Cola without sugar.
No problem. I can give you 0 calories, 0 sugar, and a great Coca-Cola taste. Here is the Coca-Cola 0 sugar that you ordered. Do it again. You still look like you need a Coca-Cola. No! Why don't you look inside your bag?
Kitchen gets a 10 out of 10.
Thank you.
This also gets a 10. Should we see the toilet now?
Sure.
This girl... Just one.
It is clean.
But not perfect.
Better than my cleaners? Impossible.
Challenge. Try the new Harpic 10X.
Compared to ordinary cleaners, Harpic stick formulation removes yellow stains 10 times better, giving you a sparkling clean toilet.
Wow.
Now you also take
the Harpic 10X Challenge.
News Updates is brought to you by
Paint and Win with Plascon. Color your world.
Day 2, the Uganda Law Reform Commission makes submissions on the age limit debate as the Legal and Parliamentary Affairs Committee resumes work following a stormy start. Also coming up, FDC party presidential candidate Patrick Oboy Amuriat calls for the release of 3 of their members arrested in Rukunjiri 2 weeks ago. And Shell Nigeria begins oil spills cleanup after a 10-year delay as Catalonia's leader says he's not seeking asylum in Brussels.
Buy paint worth 100k, get a scratch card, and SMS the code to 6565 for a chance to win great prizes, including a trip for 2 to watch Manchester United play. Paint and Win with Plascon. Color your world.
NTV, turning on your world.
When you live in a place of possibility, when you're driving Africa's growth, you never stop moving forward.
Stanbic Bank. Moving forward.
God is doing a new thing in this nation, in this generation, in the church, and all over the globe. Christ is coming back for a glorified, prosperous church. Interestingly, He has given us a blueprint, a secret like no other, and a message for this time that we are living in. Through His mouthpiece, Prophet Elvis Mbonye. You are watching the Power of Prophecy.
A city set on a hill cannot be hidden. This is what is happening to our generation. There are those that God is raising up, a new breed, who follow after the prophetic pattern of His mouthpiece. And while the